welcome back to Finally Revealed. In this episode, I want to talk about property transfers in connection with someone being pursued by a creditor or just anyone being sued for money. In the United States, you have the right to buy and sell property unless you are not old enough, which means you're not of legal age and you therefore can't legally form a contract, or you lack capacity, meaning you are mentally incapacitated, or you are unconscious or have a stroke, or you're legally incapacitated such that you're not able to make contracts, which a sale would be a transaction and a contract, or an order has been entered, either a restraining order or some type of a asset freeze order or some type of other injunction against you with regard to either all of your property or a particular asset. And in those cases where there's an injunction, the other party who requested it has to go through a series of steps in order to get it. In a divorce setting, sometimes people will rush to the courthouse if they're not getting along and they want to have the court freeze their assets. And that is an order that is fairly common if it is requested, because the court doesn't want one party to dispose or hide of assets before they have the opportunity to inventory everything and divide it up. People ask about being sued and they think that they have an asset that could be attached and sold after a judgment is entered to pay a particular creditor, and they wonder about whether or not they can sell something. Well, depending upon whether or not there is a lien against it, you have to get permission from the creditor if somebody has a lien against property before you can sell it, because they have an interest in it and you don't want to defraud that creditor. And oftentimes the documentation will say if you sell it or dispose of it, they get the money. And so you would then be able to, if you have a $10,000 piece of property and a $5,000 lien against it, someone offers you $15,000 for it, you contact the lender and you say, I have a contract to sell this property for $15,000. You arrange for a closing date, the lender gives you the payoff, and at the time of the sale, the lender gets paid, they release their lien, the buyer gets the property, and you get the $10,000, which is the $15,000 minus the $5,000 that went to the bank. And then you might use that money and do whatever you want to with it. You might take some of that money and bargain with someone who is suing you to try to make a settlement. You might pay it down on some other property, or you might do whatever you want. The point is, unless there is a lien on property, or unless it is jointly owned with someone else who doesn't agree, or unless there is a court order or other type of injunction prohibiting you from buying and selling your own property, you're free to do that. Now, in certain situations, those transactions can be undone. And I'll do a separate video on fraudulent transfers, and I'll put the link below so that you can see what those requirements are, so that you can just be sure that you don't do one of those types of transfers, because it's going to cause you more trouble than it's worth. So I hope this was helpful to you. We used to have rules many, many decades ago about dower and courtesy, and where a wife could not sell or even own property in her own right. Those rules went away. And so even if you're married, if you own property in your own name, your spouse doesn't need to consent. It's your own individual property and you can do whatever you want, unless, like I said, a divorce has been filed and an order freezing the assets and prohibiting any transfers has been enacted or put into effect. So if you have any questions about this, leave them in the comments below. If this was helpful, give me a thumbs up. Subscribe to see the other videos, and come back and see me next time. Thanks for watching.